What if he already had medical insurance? Is that an unjust enrichment to the institution and the individual who caused that? I mean, these are horrible things that happen to people, and people have a desire. It's as old as the Bible. We've gone away from the eye for an eye, tooth for a tooth. What we've said instead is that fair compensation, and now there have been discussions of caps. Yeah. Some states have had actually imposed caps of say $250,000 on this. These caps are blatantly unfair to housewives who may not be working, to minorities who may not be earning a lot. They'll say, we'll give you your economics, but we won't give you anything for pain and suffering. Well, what about people who don't earn a lot? You know, these are difficult issues.
I know that well, the American Medical Association feels that pain and suffering is a very important thing. Yeah. I don't think it's that important. I think equity is more important, making the system fairer and making sure that malpractice has occurred. And I think that having a physician peer panel is much more important than having a cap on pain and suffering. I think that's the way malpractice should go, to determine has there actually been malpractice, so physicians won't be afraid. Because I'll tell you, there is a lot of fear, you know, whether it's valid or not, there is a lot of fear among physicians, and they do things because they're afraid.
Yeah, that's a tough one. Well, let me ask you this one for both of you. What do you, because, again, we're victims of physicians of our own success, somebody who suffers a terrible bad outcome, a family doesn't have a lot of money, and now they have a small child who has years of rehabilitation and medicine, and they go, and what is it, 75% of all bankruptcies are because of health care.
That's part of the problem.
64%.
What do you do with these people? I mean, do they live on the street? I mean, just...
It's incomprehensible, isn't it?
It's incomprehensible.
That can happen.
You lose words.
And that's why the system, the healthcare system,
has to be there. That's the fault of the health. That's the fault. That's not malpractice.
If that family, if that little kid suffered because of malpractice, God forbid, but he would be taken care of. The other family.
Well, I'll give you an idea, by the way, about you worry about frivolous lawsuits and people being sued unnecessarily. We do this kind of work in our office. We get about 1,500 calls a year on people who feel they may have a malpractice case. We bring somewhere in the neighborhood of anywhere from 25 to 35 cases a year out of 1,500.
Well, how do you screen those down?
We screen them down by, first of all, we have to distinguish between the maloccurrence and the malpractice. There are maloccurrences, and you're talking about them. People who are injured, who feel bad, it was an unexpected outcome, but it wasn't the fault of anybody. And so that screening process is important, and I think that the public fails to appreciate, to some extent, how the service that lawyers do in filtering those cases, because a lot of times what people call us and we say, we're not going to take your case, this is what we found out in our review, and they say, thank you. It's the first time anybody ever told us really what happened. And we will have less anger because of it, because we know that everything was done properly.
Now you bring up a good point. Let me interrupt you, Mike. This business of, we have a rule now, right, Bob? Apologizing.
Yes.
Mrs. Smith.
I think it's a great rule. I think it should be allowed, and I don't think apologies should come into evidence. I think that the law should.
If that aborts a lot of lawsuits,
if people have made mistakes.
Yes.
You shouldn't apologize for a maloccurrence, but you should let patients know if something has gone. Right. Patients should know when things go wrong. Absolutely, but. You don't apologize for a maloccurrence. Yeah, right. I mean, you feel sorry about it, obviously. If the doctors say primum non nocere, above all, do no harm.
That's right.
And that really should be that is the motivating force for most physicians.
Bob, let me ask you this one: do you think a lot of insurance companies would rather a doctor get sued, Mike, and do you think, we think, a lot of physicians think that, well, the insurance companies say, you know what, it's easier to settle that case than to go to court and fight it. You think that happens a lot?
I think there are disputes frequently between doctors who say they didn't do anything wrong and insurance companies who say we want to settle the case.
Right.
Now, part of it, I think, is because, you know, when you've done something wrong and there's been a serious injury, it's very hard emotionally to accept it. Right. So some doctors may feel that they haven't done anything wrong subjectively, but in an objective sense, when the insurance company evaluates it, they say, look, you know, we don't want to say this to you directly, but we really think you've done it, and we're going to have. But
it also happens when there's that gray area where it's not clear whether malpractice has occurred, and it may be very expensive to defend a case, and the insurance companies may push the physicians to settle, even though it may not be in the physician's best interest. There are some insurance companies that say they will never force a physician to settle. They leave it up to the physician to decide whether or not they want to go the full route.
There are.
You think the day will ever come that we'll be able, physicians will be able to talk openly about their mistakes, you know, the way pilots do, to be in a department of medicine, you know?
Well, that's a great analogy, because the sort of the NTSB, you know, investigates crime. You know, and if we had something like that, that would be.
The Institute of Medicine study in 1999 mentioned that a lot of these errors are systemic errors, and they have to be addressed systemically, not on the basis of individuals.
Now that is a great point, and let me give you the best example in the malpractice setting. Years ago, the anesthesiologists were sued all the time, and they had the highest malpractice premiums. And that's because they weren't systemic. They didn't have systems for dealing with things. What they did was they developed really rigorous systems for dealing with things, and now they have among the lowest malpractice premiums. So that is a way to lower malpractice costs. And that's my basic theme: is the way to lower malpractice costs is to eliminate malpractice to the extent that you can. And it won't eliminate all costs, but it will certainly go a long way toward lowering premiums.
It's very easy for the anesthesiologists, though, because they have a very set way that they handle patients, and that's not really applicable to the vast majority of physicians who are in practice. But when we're talking about systemic problems, we're talking about things that go on in the hospital. And things that can be addressed.
That's right. But that leads us to, I mean, well, I don't know, we may not have time anymore.
We got 20 seconds. This is one of those shows. I feel like I just introduced my guest, and here we are saying good night. This is a complicated topic, as you folks out there know. And I'm going to have Mike and Bob back again, and hopefully through the winter months, maybe we'll find more common ground.
Let's do it.
But certainly, you folks, hope you learned a little bit. We're just as confused as you are. Stay well, and we'll see you next week.